Good morning, everyone. Thanks for joining us today. On behalf of the Real Estate Board of Greater Vancouver, I'd like to thank you for joining us for our event, What Real Estate Lawyers Want You to Know. I'm Mark Muldowan, Senior Writer and Communications Strategist at your board. We're covering a lot of ground today, so with that in mind, we'll be dedicating a small amount of time for Q&A after each topic we cover, in addition to a general Q&A period at the end of the presentation. When one of those periods open up, you can type your questions in the Q&A section found in the panel at the bottom of your screen. Depending on how many questions we have, we may be able to extend today's session to 11:45. If you can't make it, don't worry. We'll also be sending a recording of today's session. Now on today's presenter, Michael Drouillard. Michael is a lawyer with cross-disciplinary in real estate law practice. As transaction counsel, Michael maintains a substantial commercial leasing and transaction practice. As litigation counsel, Michael's practice includes disputes involving real estate or judicial review of government administrative and tribunal decision-making. He also frequently appears before administrative tribunals having regulatory jurisdiction over his real estate clients. Michael's significant and diverse connection to the real estate industry includes university-level education in commercial real estate appraisal and commercial property management through the UBC Sauder School of Business, and a previous career as a real estate salesperson and property manager. Michael teaches professional development courses for commercial and residential real estate licensees and is a real estate law instructor with the UBC Sauder School of Business. He is also presented to lawyers on topics that include collapsing real estate transaction litigation, residential tenancy law, and manufactured housing law. Welcome, Michael.
Thanks a lot, Mark. Great to be here. I'm just going to get my slides going right now. Hopefully no technical issues with that. I must say it never ceases to amaze me how many more people you can present to when it's done through an online format, because I see we have an amazing number of participants today, 382. That's amazing. Well, it's great to see all of you, and thanks for that introduction, Mark. So for today's presentation, I focused on issues that I've noticed with my real estate practice that are cropping up more and more lately. Selling tenant-occupied property and problems with the typical way realtors paper these transactions. That will be the first part of this presentation. The second part will be ethical and regulatory and fiduciary requirements when acting for owners who are all jointly selling their real estate as part of a project, like part of a land assembly or something like that. And then I wanted to conclude to discuss the very hot topic of cooling off periods. We all know that the BCFSA recently closed the consultation period for this one. And I'm going to discuss what I think they're going to do. I don't know what they're going to do. No one knows what they're going to do. But by looking at the past and how BCFSA and Real Estate Council have regulated these types of issues in the past, we can kind of guess how it will regulate this issue going forward. So without further ado, I'm going to go into the first topic, that's selling tenant-occupied property. So increasingly, I'm getting litigation files on this issue, and it seems to me that the subject of selling tenant-occupied property, it's higher risk than ever before in the residential context, particularly when the purchaser wants vacant possession of the property. And some of the risk factors I've noticed, for example, this is kind of done and over with, but when COVID first hit us in 2020, and the government imposed an eviction freeze, that had the effect of causing multiple contract breaches across many transactions in British Columbia, because essentially the government foisted this eviction freeze onto the public without any guidance about what to do, for example, with ongoing transactions where a vendor had promised vacant possession. And it caused a lot of harm to vendors, in my view, because of that. It's getting riskier. There's now, as of a couple of years ago, the NDP government created this obligation for a purchaser or a landlord to pay 12 months rent if the landlord does not actually use the property for their own personal use as set out in the notice to end tenancy. So that's a major risk factor for owners of property nowadays. There's increasing reluctance of tenants to leave voluntarily. Rents are flying up, getting only higher. And many tenants who receive notices to end their tenancy for landlord's use, they may be entering into a new rental marketplace where rents are higher than they ever were before. And so there's a real reluctance for tenants to leave unless they absolutely have to. The other issue too, I'd like to point out is it's more difficult than ever to get a prompt hearing before the RTB. It used to be that you could get an eviction hearing in 1 to 2 months, but particularly since COVID has hit, it's taking longer than before. It could be 3, even up to 5 months just to get a hearing. And I've also noticed that tenancies seem to be more common due to vacancy tax laws. Property owners do not want to pay vacancy tax, so they're taking steps to avoid it since by renting out their property. So it's a bigger issue than it ever was before. Now, the most common approach that licensees use when dealing with a purchaser who wants vacant possession is, of course, they'll set it out in the contract. So what they'll do is they'll really do 2 things. The buyer, the buyer's agent most likely, will put a clause in the contract setting out that the purchaser is requesting the vendor to deliver a notice to end tenancy for landlord's use of property. This has to be in the contract in order for the seller to issue a notice to the tenant. And it's required by the Residential Tenancy Act. So they'll have that clause in there. Section 5, which is in your standard form contract, the possession clause, it'll typically say that the property has to be vacant on the possession date. Won't say anything else. It'll just say that it has to be vacant. And so other than these 2 clauses, nothing else is really stated in the contract about the matter of the tenancy. And I guess the idea is that the buyer expects the seller to give the notice to end the tenancy, and all the parties are expecting that that tenant will move out as required by the notice, and then on completion the property will be vacant, and nothing else is really stated about the matter. And the fact that this is the most common approach that licensees use, it's not a surprise to me, because this is actually the approach that up until recently Real Estate Council and BCFSA had recommended to licensees, that they put in clauses dealing with these 2 issues, but without any other guidance or discussion on the matter. I noticed as of last night, it seems that they've removed their advice about what clauses to use, which is interesting to me, because right now there's no advice then if you go to the BCFSA website on what to do when dealing with tenant occupied property. And so this approach is it's quite problematic, actually, because the problem is that if the contract simply says that the seller has to deliver the notice to the tenant for vacant possession and nothing else is stated about the matter, it's problematic because the parties have not reached an agreement about what happens if the tenant fails to leave on the possession date. And so by leaving it open like this, it leaves a number of serious questions unresolved. For example, if the property is not vacant, if the tenant is still there, does that mean that the purchaser can terminate due to a fundamental breach of the contract? Is it a breach of Section 9, which is the title clause, saying that title will be free and clear of all encumbrances except those agreed to? Because after all, an ongoing tenancy is technically a charge or an encumbrance on title, even if it's not actually registered on title. And then on the other hand, if the tenant fails to move out, is the purchaser still required to complete? And is there a remedy only to sue for damages due to a minor breach of a non-fundamental term? And so the answer, the default answer is actually not entirely clear at this time. There is divided case authorities on this issue, and it's not entirely clear based on your standard form contract what happens in this scenario and who gets to say which party is in breach and what has to happen next. So it's a real problem. And And it's a real problem because then what happens on completion is it can turn into an aggressive posturing between lawyers about where the purchaser's lawyer will say that the seller has breached and that they're entitled to withdraw, and they might use that as an opportunity to try and pressure a price reduction or something like that. Whereas the seller, on the other hand, will be insisting that the buyer has to complete. And so this is a huge concern to me in my practice because it keeps coming up. I keep getting these files every 1 to 2 months. And the issue is that both the vendor and the purchaser, they have an incentive to sort this out ahead of time, this possible risk. They have an incentive to allocate in advance the risk and to decide what will happen if a tenant doesn't leave on the possession date. And so I think for all the licensees here, that it would be a very good practice if you put your mind to this in the contract, because the time to put your mind to this issue is when the contract is being drafted. And on this issue, it's going to be a negotiation point because purchasers and vendors have competing interests. The purchaser the purchaser may want a right to terminate, and I understand that. They're going to want certainty that the property will be vacant on time. They may not want to deal with the tenancy post-closing, and they want to know that they're going to be able to move in there on time without issue. But the vendor, on the other hand, is going to prefer that the purchaser close. And the vendor has very good reasons for wanting the purchaser to close. I mean, first of all, it wasn't the vendor's decision to demand vacant possession. That was the buyer's choice, and arguably it was the purchaser's risk. And the other major issue a vendor is going to have is it's kind of unfair to the vendor to impose this requirement of vacant possession on the vendor, because it's not up to the vendor, it's up to the tenant to voluntarily decide to leave. And so most vendors are not going to want to have responsibility for something that's not within their control. And so there are competing interests here. And I think that, again, as licensees, it's your job to try and address this issue in a way that works for both parties. Other issues that I wanted to mention that might have to be resolved is, for example, let's say the tenant disputes the notice to tenancy. Let's say they don't believe the buyer's going to move in. Well, who handles the hearing before the RTB? Does the purchaser handle it? I mean, after all, the purchaser's the one that asked that the notice be issued. Or does the vendor handle it? I mean, after all, the vendor is the landlord, right? Does the purchaser have to cooperate if the vendor's going to handle the hearing and show up at the hearing in support? These are other issues that I've seen in my practice that are not resolved by the typical way that licensees paper deals. Another simpler issue is who pays the month of free rent? The vendor? I mean, the vendor's the landlord, right? It's their obligation to pay the tenant the rent, the 1 month free rent. Or is it the purchaser's obligation? I mean, after all, the purchaser asked that this notice be issued in the first place. Why would it be fair to require the vendor to pay 1 month's rent when this was what the purchaser wanted in the first place? Another one I don't have here is what if the purchaser doesn't complete? What comes of that notice? Is it going to get withdrawn? This is an issue that I've kind of wondered about in the back of my mind, because what if a purchaser asks that a notice be issued on the basis that they'll move in? They bail on the deal for one reason or another. They don't get financing like they said they had. What's the vendor supposed to do? The tenant thinks that they have to move out. And if the tenant finds out that the property wasn't used for the purpose stated, someone's going to get dinged with 12 months rent possibly. So these are a number of issues that aren't resolved by the typical approach that licensees use. And for the purpose of today's seminar, I don't have the time or ability to go into every possible scenario and how to deal with it. But just as a starting point, I wanted to share a sample clause that might work for example, a vendor. So this is a vendor-friendly clause that I'm not giving you legal advice about your circumstances. Don't use it and then sue me after. It's just a clause that I wanted to introduce to all of you just for discussion purposes so that I can get the wheels turning in your minds about how you might deal with these issues. So if I'm acting for a vendor and I feel that I can ask for this, I might ask that this clause be inserted where I'm not going to read it out. It's quite a mouthful. You can see it yourself. But the point of this clause is basically say that if the seller is asked to serve a notice to end tenancy because the purchaser wants to move in, the seller is going to do that, and they'll do their best to try and get the tenant to move out. But if the tenant doesn't move out and if they remain in possession of the property on or after the possession date, the buyer still has to close. And so this deals with the concern that some purchasers will exert pressure on the seller and say that, well, if the property isn't vacant, I'm going to collapse the deal and put you in a very serious financial predicament. And so I'm not saying that this is the perfect clause to use for every circumstance. I'm saying this is a starting point for a discussion that I think licensees need to be having, because more and more I'm seeing problems with the sale of tenant occupied property. I'm seeing tenants disputing these notices. I see them simply refusing to leave. I see them leaving, but maybe not exactly on time, and maybe 10 to 30 days later, and this creates real contractual problems for your client. And I think that it would be prudent if you put your mind to it and deal with some of these issues that I've discussed in part one of my lecture. So that's part one, and I think we're going to open it up for Q&A now. The idea is that we're going to have a little Q&A after each little section of this presentation.
Thanks, Michael. Yes, so if anybody has any questions specifically on this topic, please put them into the Q&A section at the bottom of your screen. I'll read them out loud and Michael will answer them. All right, Michael, so first question we have here. For purchasing a tenanted property, can we include the notice served by the seller and acknowledged by the tenant that the property would be vacant by, say, end of March in the contract?
Well, absolutely, you can. But then that goes to my prior concern is you can say that everyone acknowledges that the tenant is supposed to leave on a certain date, but ultimately it's up to the tenant to leave, right? And the issue that I'm trying to capture today is having the buyer and seller put their minds to what should happen if the tenant fails to leave. But I agree, you can put that in the contract, and I understand that many licensees do that already.
Thank you. Question here from Alex. He's looking for some insight for the purpose of why BCFSA removed the clause regarding the purchaser requesting the seller to serve the tenant with a notice to vacate.
And that's really interesting to me, because get this. So I swear I looked at this as early as a couple of weeks ago, the BCFSA used to have clause that recommended what to do for the sale of tenant occupied property. The problem was that the way BCFSA recommends it be dealt with is the common way realtors paper these deals, which I've just discussed is highly problematic. So the BCFSA was not offering enhanced language to deal with the situation where a tenant fails to leave. And I could be wrong, but I pretty thoroughly checked the BCFSA's knowledge database last night in the clauses section, and it's no longer there. I don't know what happened. I mean, I've been part of several consultations with the BCFSA where I've expressed concern about how realtors are papering these deals, and perhaps they're reconsidering. I don't know. I'd like to think that I have influence, but I suspect I don't. But that's something I just noticed last night, is that there's no longer a clause on the knowledge database for how to deal with the tenant occupied property sale.
Thanks. That segues nicely into the next question here from Elisa. Have you heard of any interest by the BCFSA to fix any of these issues?
It's a good question, and I absolutely have not heard anything. And I'm wondering if they should, because this really particularly started when COVID hit and the eviction freeze went in place. That caused a whole bunch of innocent vendors to be stuck in a rock and a hard place, and there was no comfort or protection provided to these vendors. And I personally had to deal with vendors who had to, in my view, unjustifiably give price reductions to buyers who are threatening to crater the deals on this basis due to something that the seller had no control about. So I don't know, but I'm hopeful it's something that's on their to-do list to look into.
Thanks. I have a question here from Faye. What other terms can you point to protect the buyer and to ensure vacant possession with a tenant-occupied property?
Yeah, and it's a really good question. And one of the issues I had was that for the purpose of this presentation, I can't give recommended language for every scenario. Even the clause that I've given, you know, that's just for a particular scenario when you're acting for a vendor. And what I hope to see, what I'd like to see is BCFSA offering a number of different clauses for a number of different situations so that licensees don't have to go to lawyers and ask to get a clause drafted for them. Ideally, BCFSA would offer recommended language for different situations so that would give all of you a starting point, because to answer that question, what would I recommend for a buyer? You know, there's really, if the buyer wants the right to back out, then there should be a clause in your contract that really sets out that if the tenant is still there on possession, that it's a material breach of the contract and the buyer can terminate. So that, like, on one end of the spectrum, that's what the buyer would most prefer to have. But that might then become the subject of negotiation between the seller and the buyer, because the seller might say, no, you can't crater this deal and put me in that position. I'd like you to instead complete. And there might be a negotiation about that. I mean, one of the complexities too is that there are a number of reasons why a tenant doesn't move out, from anything from that the seller screwed it up, served the notice wrong, prepared it wrong, or the tenant is just wanting to pick a fight, basically on the other end of the spectrum. There's like all sorts of different reasons why tenants don't leave. And so these matters, they all have to be negotiated between the buyer and the seller and just thought about in advance. It's not really for me to recommend a whole bunch of language about this. I think it's really for the BCFSA to deal with this very common issue. And I mean, I see we're getting 31 questions on this. I mean, this is obviously a hot topic. I think a lot of you are having to deal with tenant occupied property. And so I'm hoping to see some change in this area.
Thanks, Michael. Another question here from Angie. Could a buyer extend the lease, tenant lease agreement to, say, a maximum of 3 months while asking for signing a mutual end of tenancy with the tenant before completion?
The answer is that you can shake out any deal you want with the tenant as long as the tenant agrees to it. And so the issue with the mutual agreement to end tenancy, I see a couple of questions about that is, yeah, if you present a mutual agreement to end tenancy to a tenant, the tenant can sign it. And that's again, you're hoping they'll leave on the date that they say they leave, but there's no actual guarantee that they'll leave even after signing one of those things. And so, but my underlying issue with that is you can't make a tenant sign a mutual agreement to end tenancy. And so if the tenant doesn't want to sign it, there's nothing you can do about that.
Thanks, Michael. Question here from Brian. Does this apply to even for commercial property tenants?
It's a good question. So for commercial properties, it's a very different kettle of fish in that residential tenancies are very highly regulated tenancies where you have to use special notices, you have to use special tenancy agreements. But commercial leases, they're more like they're like the Wild West. You get what you bargain for, and really what the lease says governs the matter. I've seen some commercial leases that say that a landlord can terminate the tenancy if the property is sold, but most commercial tenants are going to strike that out. So usually it's very dependent on whether or not the tenant has a fixed term lease. And in that case, the commercial tenant is going to get to stay and there's nothing you can do about it.
Thanks. Question here from Zeu. For the purchase of a tenant property which got damaged due to flood, for example, or due to the nature of the market or unconditional crash offer, can a buyer back out due to fundamental differences?
Okay, so it's a really good question. It's a difficult one to generalize about, but I will tell you, I'll try, which is to say that if there's some kind of flood or water damage from the time the contract is entered into to the time of closing, that's an issue in that there's a clause in your standard form contract that all of you use that sets out that the property has to be substantially in the condition that it was viewed, and you'll write the date whenever the property was viewed. And so whether that flooding gives a right to terminate is very fact dependent question. I don't want you to think you can apply it to your own situation if that's what you're dealing with, because it really depends on a number of different factors. And one of the main factors, I think, is then how badly the property was damaged, because minor damage probably is not going to give you a basis to say the contract is fundamentally breached. Whereas if it was catastrophic damage that rendered the property uninhabitable, might be a different story, because then you're substantially not getting what you bargained for.
Right. And Zay just has a quick follow-up to this. Should the buyer and seller sign an addendum to address the subsequent event after the original contract is signed?
Well, the problem, though, is then it's too late because the contractual rights have crystallized already. And I would encourage buyers and sellers to be pragmatic, practical, and reasonable, and maybe come to some kind of agreement. But the thing is, once the contract is signed, it's set in stone. You can't make the other side agree to an amendment. And really the time to deal with those kinds of issues is when the contract is first entered into. And you'll see with commercial real estate transactions, there'll often be lengthy and complex clauses dealing with what happens if there's damage before completion. You don't really see that in standard form contracts. And so my only advice about that is to say that if you're the best time to paper that issue is when the contract is first entered into. Unfortunately, BCFSA offers no advice about clauses you can use for this scenario. And so it's something that if you think this is going to be a problem, you shouldn't really be drafting custom language about these kinds of things. Unfortunately, you might need legal advice, but it's just a risk of your business, I guess. The standard form contract all of you use sort of deals with the matter, but not fully. And that's kind of how it is, unless you fundamentally change your approach and put in a clause dealing with that issue more fully.
Thanks. Question here from John. Many owners will rent rooms in a residence versus having a tenant agreement for the entire property. What are the implications of this on the status of sale?
Yeah, and so it's really interesting because it depends on how the rooms are rented, because on one hand, if you have a roommate scenario where you're renting to like 2 or 3 people under a single tenancy agreement, you can kind of treat them as one, which means that if the purchaser wants to move in, you serve a notice. It applies to all of the roommates under their joint tenancy, and they'll all have to leave. But sometimes owners rent rooms in a home under separate tenancies, where you might have someone who lives in one room and they've signed a tenancy agreement with the landlord, and then you have someone who lives in another room who has another separate tenancy agreement with the landlord. And so you'll have to treat them as separately in that case and make sure that everyone gets the notice, but on their separate forms. And there's actually a policy guideline from the residential tenancy branch that discuss how to deal with joint tenants versus co-tenants of the same parcel of land. I was wondering, we're not beating down our questions, they just keep going. I think I should move on to the next topic though, and perhaps we can push some of this off until the end.
Yeah, I was just about to say we're running a little low on time here. So let's move on to the next topic. Thanks, Michael. We'll see you in a few minutes.
Yes, well, you'll see me now. I'm going to get to part 2. And so part 2, this is a little more of a niche topic, I understand. I know many of you don't do this, but you may. And so it's good to think about this. And so I wanted to give some advice about licensees acting for multiple owners in a joint listing. And so what I'm thinking of when I talk about this today is I'm thinking of strata wind-ups or land assemblies where really the owners are expecting their licensee to market the properties jointly. Now, for those of you who took legal update last year, there was a topic about acting for owners of strata lots within the same project. That certainly has its own share of ethical and regulatory issues. But for today's presentation, I'm primarily thinking about the joint listing with owners who are expecting the licensee to jointly market the property. So this kind of joint listing, it creates unique ethical and regulatory issues when acting for multiple properties at once. It creates issues relating to transparency of price and contract information between owner clients. As a licensee, you have to manage your clients' expectations, including managing the sometimes competing interests of multiple owners. And in terms of your regulatory obligations, I wanted to highlight some of the real estate services rules that particularly are at play with a joint listing. And so we have Rule 30 sub E, which requires you have to maintain the confidentiality of information regarding a client. And yet on the other hand, Rule 30F says you have to disclose to the client all known material information respecting the real estate services. So this is a problem because how do you reconcile these obligations between two clients? How can you, on one hand, have an obligation to one client to maintain their confidentiality, yet on the other hand, have an obligation to share to the other client all known material information regarding the real estate services? Rule 30 sub L says that a licensee has to take reasonable steps to avoid a conflict of interest. So all of this to say, my worst case example, what do you do if a developer is giving a better offer to one of your clients, but not the others? Are you in a conflict of interest? Like what do you do about that? Then, so those are your real estate regulatory rule requirements, but you're all fiduciaries of your clients. And so there's actually common law principles to consider. And so the courts, they typically characterize licensees as fiduciaries of their clients. And that comes with all of the common law fiduciary duties of loyalty, confidentiality, and avoiding conflicts of interest. And if a licensee breaches their fiduciary duty, that can include an obligation to pay the commission that was earned because of that breach to the aggrieved client. And so it's a real liability issue for licensees to think about when they take these joint listings. Now, and so how do you deal with that? Well, the answer is that not only the courts, but the BCFSA recognizes that there are situations where you can't really offer the full range of fiduciary duties that you normally would to your client. And courts accept, for example, that a fiduciary can modify or limit those duties by contract. But this is also recognized by the real estate services rules. Rule 31 also permits licensees to modify their Rule 30 obligations to a client with a written services agreement. So one of the issues that I'm going to discuss is modifying those duties to your joint clients. I'm going to discuss how you have to take a different approach. You have to take a common approach where all for one, one for all. You're writing to everyone. You're not favoring any clients or anything like that. However, before you even take the listing, can you take a common approach, or is taking the listing in the first place not acceptable? So the first question you have to ask yourself is, can you take this listing in the first place? Because if you can't provide competent and diligent representation to each client, you shouldn't be taking the listing. You also shouldn't act without getting their informed consent to modify duties regarding conflicts and confidentiality, because you're simply not going to be able to offer the same degree of privacy and representation like you would when acting for one client when you're acting for multiple clients. And so when I ask this question to all of you, I'm asking you to think about usual issues. Like, do you have a pre-existing, very deep relationship with one of the clients versus the other client? It may not be appropriate to take the listing on in that case because you're just too aligned with one of the owners versus the other owners. And so that's the first thing you have to think about. But then I also want you to think about your listing agreement, because please don't just get like 10 clients to sign 10 MLS listing agreements that just don't really say anything beyond what they normally do when you take a normal listing. It may not be appropriate to use the standard form MLS listing agreement as is. You may have to get your clients to sign a joint MLS listing agreement. And all I mean by that is your standard form MLS agreement, but with clauses added dealing with the fact that you're going to have to limit the scope of your duties to your clients. And so this can be a pretty serious undertaking. I'm saying, first of all, draft your joint listing agreement with the assistance of your managing broker and possibly even legal counsel. I mean, if there's a lot of money involved, you don't want to skimp out and on that issue. You want to make sure that these issues are being properly and fully considered. And so some of the issues that I think your listing agreement should deal with is it should set out that your client agrees that you can't treat information confidentially between clients. You have to share all relevant information with all of your clients. So, for example, if the developer makes the offer to one of your clients in the joint listing, but not the others, everyone's entitled to know that. You can't disguise or hide the fact that one of your clients got this great offer from the developer from your other clients who are expecting you to act fully for them as well. You have to get your client to acknowledge that the fact that you're sharing information this way, it's a limitation on your ordinary obligations under the common law and the real estate services rules. This is part of getting their informed consent. They have to understand that, okay, this is a different type of listing than a typical listing. And it means that my realtor is not able to act the same way as he or she would if it was just a kind of a more standard listing with one client. You should also have a mechanism dealing with what happens if a conflict develops between your clients that can't be resolved. You should set out what's going to happen in that case. You might have to withdraw for some or all of the clients. It's something that you can set out in the agreement. And it should have a recommendation to seek independent legal advice. And so my thing is that this additional contractual language doesn't have to be lengthy. It doesn't have to be this big, intimidating listing agreement, but it has to deal with this issue, because what I'm trying to say is that your typical MLS listing agreement, it's not good enough for a joint listing when you're acting for multiple owners who are wanting their properties jointly marketed. The other thing I wanted to conclude on that with that is this idea of taking a common approach with your clients. You have to change the way you interact and relate to your clients in a joint listing. You should get all their emails going and establish kind of like an email list for all of them where you share information equally with owners as it comes to you. And you're always being aware of possible issues that could arise and developing ideas on how you're going to deal with these issues if they do arise. So for example, what are you going to do if an offer is made to one of your clients that appears to be better than what the other clients may receive? Are you going to, for example, first of all, disclose this to everyone, but also maybe recommend that they get independent legal advice? And the reason why I say that is because as a realtor acting for everyone, you can't pick and choose favorites. You can't give some advice to some client and not give it to the others. And it may be that this is a case where there might be a conflict developing between your clients, and you have to be in a position where you're not taking sides and you're making sure everyone knows what they need to do about this developing issue and how they might need to get someone in their own corner, like a lawyer, giving them independent legal advice solely in their interests. And so the point being is that if you get a joint listing, these can be quite lucrative, and you should pursue them if you can, if that's your interest. But I just want you to be really aware that it requires a different approach than you normally would for a regular listing. It even requires a different approach to if you have multiple listings within the same development, if they're not marketed as a group. And so that's the end of part two. That's the end of part two. So we'll have a quick Q&A on that.
Thanks, Michael. So questions for this section. We have a question here from Brian. When acting for multiple clients, how would we go about forming a syndicate instead?
So what Brian is discussing is it's slightly different than what I've been discussing, because he's discussing how the owners should organize themselves for a project where they might all want to like buy a development property or something like that. And that's a whole, I could discuss that for hours on end about, different joint venture, limited partnerships, and other types of common real estate ownership structures. And I will say, though, that because I'm lasering in on the ethical and regulatory duties of realtors, on the buy side, all of these principles that I've discussed, they're the same. So if you're going to act for multiple buyers, you need to have a joint understanding with them that it's all for one for all. What one client tells you is not a secret from the other clients, and you're acting for all of them at once. And to the extent that a client needs individualized advice, they're going to have to get their own legal counsel or other expert helping them exclusively, because you're acting for everyone in that scenario. And so I'd like to say that all of these principles I've discussed today apply equally when you're acting for multiple buyers.
Thanks. Question here from Jordy. As to the joint listing concerns, is the prevalence of land assemblies causing these?
Short answer, yeah, that's a common area where I've seen it. I see it a bit in strata windups, although strata windups are still not very popular. But it's this idea of a licensee acting for multiple individual owners who want their lands marketed jointly. And so the most common context where you see that is a land assembly, as far as I'm aware.
Thanks. Question here from Michael. Could you have a clause stating confidential information relating to the other property not being disclosed to the client?
You could try that, but I just don't get how that would work. I just don't get how that work. You could, because how is it that you could have a situation where one client is receiving information that is very relevant to the other client? And how can you as a realtor be stuck in the middle of that where you can't disclose that to everyone? Because everyone thinks you're acting for them. That's the issue. I would say that if you're going to do that, definitely get legal advice, because it's a very tricky situation. I've never heard of it in for example, the law context when lawyers act for multiple clients. I would never accept a retainer like that because I just don't think you could do it. But I'm not saying no, it's super can't be done. I'm saying that's a very high risk type of relationship that requires close consultation with your managing broker and with counsel.
Thanks. Just asking, is there any more questions about multiple owners and joint listings?
That's all right if there's not, because it's time for the next topic, I think. And I just can't believe all the questions for tenant occupied property. I knew that that's a serious issue, and I'm just hoping that something is done about it. But yeah, so Mark, shall I move on?
Go right ahead. Thanks, Michael.
Okay, perfect. Okay, so this one's kind of fun because it's just me speculating. And so I wanted to talk about the very exciting, very interesting news that's been hitting the media about cooling off periods and other major industry shakeups. So many of you know that recently the BCFSA recently concluded its consultation with the public. It's going to present a report to the Minister of Finance very soon, this spring. And the BC Real Estate Board, I really encourage all of you to read it. It's a really interesting read. They published a white paper in response to this consultation process called A Better Way Home, Strengthening Consumer Protection in Real Estate, where they kind of respond to what they think the BCFSA will do. There's a lot of pushback to it, but then the BC Real Estate Association is proposing its own ideas on how to deal with the issues of blind bidding and cooling off periods. And I wanted to say that I get why this is an issue, because in addition to problems with tenant occupied property, this is another common area where I'm receiving litigation files where folks are doing whatever it takes to prevail in a multiple offer situation, and then they're left with horrible buyer's remorse, and there's nothing they can do about it. And I think it's incredible the number of buyers that are willing to take such risks with one of the most important investments they'll make in their lives, at least one of the most largest in terms of financial dollars. You'll do all this inspections and due diligence when you're buying a car, but you're willing to just go in the blind and hope for the best for a property that's worth much more than a car. But I get it. That's just how the market has been lately. And so I totally understand why this issue is being looked at. And so the question is, what is the BCFSA going to do? Because we don't know what they're going to do, but we can kind of guess and speculate by looking at what BCFSA has done in the past with past controversies, like with limited dual agency and quote unquote shadow flipping. I kind of roll my eyes when I see that, because it's just assigning a contract. It's not necessarily some nefarious thing, but shadow flipping sounds better in the media than assigning contracts. So the first thing I do when I look at this is I first think about, well, what's the mandate of the Real Estate Services Act? Why does RESA exist? What does it do? And in my opinion, RESA is consumer protection legislation for the regulation of licensees. It doesn't regulate real estate transactions generally. It doesn't apply to two private people who don't use a licensee, for example. It's designed to regulate licensees, and licensees are a huge part of the real estate marketplace. Many transactions are done through licensees. Many are not, though. And so what I'm suggesting is that because the mandate of RESA is to regulate licensees and not real estate contracts generally, I suspect that the BCFSA is going to deal with this issue through increased regulatory pressure on licensees, which means there's going to be more rules, regulations, disclosure forms, and that kind of stuff for all of you to be worried about if this goes in how I think it's going to go in. The reason why I say that is because I look again, how was this dealt with in the past? And I'm going to show a series of slides that look very similar, and they're very similar because I'm trying to make a point here, which is that limited dual agency, how did they deal with that? Well, they did a dramatic change to the Real Estate Council rules. They created this concept of designated agency. Just going to fix that typo. And so it meant you could no longer just enter into a limited dual agency agreement. There are now increased regulatory requirements. There's this new concept of designated agency very different approach. They also changed the standard form contract used by licensees. It has different disclosure language in it. Importantly, these standard form contracts that all of you use, there's no legal requirement that they be used by private persons. So private persons don't have to use this standard form of real estate contract. It's something that all of you use. So that's how they dealt with limited dual agency. But then the other major one, shadow flipping. So how did they deal with that? Well, they changed the real estate council rules, now the real estate services rules, new disclosure forms, new rules about having to inform your clients about the risks of assignments. And the other major change was they changed the standard form contract used by licensees. They introduced the clause that prohibits assignment. And they also introduced a clause saying that profits on assignment have to get paid to the seller. But again, the public's not required to use this contract. This is something that licensees use, many people use, but there's no legal requirement that two people not using a realtor have to use this contract. And so the theme I'm trying to demonstrate here is that historically BCFSA deals with this issue by putting increased regulatory pressure on licensees, making them have to fill out new disclosure forms and that type of thing. And so how do I think BCFSA is going to deal with this? Well, just like in history, I think they're going to change the real estate services rules. They're going to put in new disclosure forms, new regulation, further increased regulation of licensees. And I think they're probably going to change the standard form contract used by licensees. They're probably going to introduce a clause dealing with a cooling off period or whatever they end up doing. They're probably going to change the standard form contract. Yet again, though, the public is not required to use a standard form contract or have any of its terms included in their offer. Okay. And so like my thoughts on this, to the extent my opinion matters, are as follows. Well, first of all, I get it. Real estate transactions are increasingly complex and regulation is important for a fair marketplace. I remember when I was a licensee, and that wasn't too long ago, back in 2001 to 2008, it was much simpler. There was no transparency registry. There was no vacancy tax. It was a much simpler time than it is today. And so I agree regulation is important for a fair marketplace. I also think that workarounds that evade regulation are harmful and a threat to your industry. And I also think that workarounds that give regulated professionals, such as yourselves, a disadvantage over unregulated persons are harmful. And when I say that, licensees are particularly vulnerable to unregulated marketplace activity. If I want to list my company on a stock exchange, there's no way I can do that myself. I have to use licensed professionals to help me do that. Whereas real estate is somewhat unique in that there's always this persistent threat of unlicensed people or the public just dealing between themselves without the use of a realtor. That's kind of unique to your business. And so all of this to be said, given that the mandate of RESA and the BCFSA is just to regulate licensees, I seriously question whether it will be effective to try and deal with the harm addressed by a cooling off period by putting more regulatory pressure on licensees. And so the example I love to give for this issue is, let's say BCFSA regulates cooling off periods. They put in the standard form contract that there's a cooling off period. They require realtors to use cooling off periods or to disclose to their clients the risks of not using cooling off periods. And let's say I'm in a blind bid multiple offer scenario. What's to stop me from ditching my realtor and making a subject free offer direct to the seller with a deposit paid directly in a blind bid? The realtor is still going to get paid, the listing realtor, but what's that's going to do? I'm going to annihilate my competitors because the seller is going to want to go with the offer that's binding upon being signed, as opposed to the other offers that are subject to cooling off periods that are presented through realtors. So I just seriously question whether the approach BCFSA has taken in the past is going to be effective to deal with this issue, or if it's just going to be unfair to licensees. And so, in my view, if they want to tackle this issue and tackle it correctly, they're going to have to fundamentally change real estate contract law. These changes are not just going to have to be something that stops at the licensee level. It's going to have to affect any contract for the purchase or sale of residential real estate in BC. But that's opening up a can of worms in a much more complicated process. In order to do that, there would have to be legislative amendments. So the legislature would have to create a new law dealing with real estate transactions. And that's certainly much more difficult to implement compared to just having new rules added to the real estate services rules or changing the standard form contract. I did have a comment on the BC Real Estate Association report about strengthening consumer protection. So the BC Real Estate Association is pushing back on this idea of a cooling off period and restrictions on blind bidding. But some of the alternate proposed ideas by BC Real Estate Association, they still suffer the same problem, which is they are ideas that only put regulatory pressure on licensees. They don't change the real estate market generally and how transactions are done. And so it's a real issue. It'll be interesting to see how it gets implemented. But I guess, again, to the extent my opinion matters, would suggest that the industry needs to receive this next part with some skepticism and concern, because although regulation is good, it shouldn't come at the expense of your business and give people who are not regulated an unfair advantage over you. So that's perfect. I finished just in time, although I am sticking around for questions after.
Thanks, Michael. Just as an FYI, because I've seen a few questions come up there about the white paper and where you can see it. You can read the white paper right now at membernews.rebgv.org. That's our new member news site that launched a couple of weeks ago. If you go there, it's the top story that's on there right now. It's titled BCRA announces 30 home buying policy recommendations. You can go there, you can watch the press conference that they had for that, and you can also see the actual white paper itself and read it. And with that in mind, I have a question here from Elisa. What do you think the cooling off period could create another problem, or sorry, another form of bully offer? It does give the buyer a lot of opportunity to abuse the system.
Yeah, and I it's interesting because in the BC Real Estate Association's white paper, they specifically comment on that concern. They say that licensees are concerned that this will just create a basis for buyers to make bully offers so that they defeat their competitors and then say, kidding, no, I'm actually not going to buy the property unless you knock 50,000 off the purchase price or something like that. And that's a concern. That's what cooling off periods do, because you could have a requirement that if the cooling off period is abused that way, that the buyer has to pay damages. But who wants to sue a buyer? Like, lawsuits are expensive, difficult, cumbersome. That's no answer to the problem. So I think that, yeah, that's a specific and real risk that BCFSA is going to have to sort out if they want to do this.
Thanks to the question around these BCFSA regulations from Casey Lamb. Do you think there would be any regulation to restrict listing pricing way below market value? Will the listing agent be required to provide a CMA, for example, as an explanation when submitting the listing?
I sure hope not. That would be unworkable, unrealistic, and way too much regulation. I haven't heard of that being done, but on the other hand, and this is where advocacy from your industry is quite important. I heard, and I saw this in the white paper, that BCFSA, or it might have been someone else, I don't want to point the finger at BCFSA on this one, that they were thinking that there should be a requirement that unsuccessful bids have to be retained by the brokerage and the records kept at the brokerage for a certain period of time. What a waste of paper and administrative hassle having to keep all of these dead offers on file, and for what purpose? And so I would hope that that's not the case, but the industry has to be on guard for sure for regulation that means well, but is just getting in the way of business. But I haven't heard of that particular idea. Sure hope that that doesn't happen, because that seems obviously unworkable to me.
And that segues into the next question here from Christopher. Would a registry type system like what they have in Ontario not be a better approach to blind bidding?
And yeah, I defer to the white paper on that issue, because there's a really good discussion in the white paper about the effect that that registry has had on the marketplace. I think that the BC Real Estate Association's point is that it's better than what's being proposed here, although not necessarily the best way to go about it. And to be honest, I'm not familiar with the data on whether or not that's actually been good or not. I still have that lingering concern, though, about the regulation of licensees at the expense of licensees, giving them a competitive disadvantage over people that don't use licensees. But I get it, that there's a real problem with this blind bidding and subject free offers and all that stuff. People are doing ridiculous things. I mean, I would also say, just to stop rambling on that issue, the problem with multiple offers is not just because of multiple offers. It's a symptom of a sign of a marketplace that is too seller friendly. There's been a prolonged real estate boom, and it's a very interesting market, especially post COVID. And the reason that sellers and buyers are finding themselves in this multiple offer situation more and more, it's also a product of the market we're in. And so really change also has to come with increased supply and that type of thing, so that buyers do not feel that they have to make these high risk subject free offers.
Thanks. I have a question here from Rob, which is also a question for me, because I had the same thought when I saw these proposals coming forward. What stops one buyer from tying up several properties at once if they have no consequences for doing so? Like, say if I'm, a more sophisticated buyer that has some deep pockets, what's preventing me from tying up a bunch of properties in an area and then using the cooling off period to choose which one I'd like, tying up the competition?
Yeah, I don't disagree with you. I mean, here's the thing is, at the very least, if there's going to be a cooling off period, a seller has to wonder, well, can I at least make them put up some money as some kind of deposit, so they're not just locking me down with a piece of paper? Like, they have to put up some money in trust. But that's not a complete answer either, because again, the money goes into trust and there's a dispute. Are you going to go to court over a $10,000 deposit? I mean, that's a lot of money, don't get me wrong, but it's not necessarily practical to have a court fight over these issues. And so, yeah, that's another issue with this. And this is also discussed in the white paper about problems they see with cooling off periods.
I have a question here for Michael. He's wondering if there's any side effects for the cooling off period that you can think of. He mentioned some thoughts of maybe price increases or more for sale by owner. But is there anything else you could think of that might be an unintended consequence of this?
I think that I think I've discussed the main one. The white paper discusses a number of other issues. But I think that this is probably the bigger issue I see, is this has never been done before in this province, and it's going to represent a fundamental change to how real estate is done if it goes in. And initially, buyers, sellers, and licensees are going to screw it up a bunch as everyone adjusts to this rather dramatic change. And that's going to cause unhappiness and hardship, at least initially. And whether the marketplace adjusts to this new normal, I don't know. But there's certainly going to be issues implementing this that will cause hardship to all real estate market participants.
Thanks. One last question here around these sort of issues before we're going to open up to the more general questions. And this one is a little bit tangentially related. Do you deal with any legal cases from the unregulated market, where there are no licensees involved? And if so, can you share some insight on any major issues that typically crop up? And that was from Rasica.
Okay, yeah, I mean, and I don't often deal with pure FSBO situations for sale by owner with buyers who are also unrepresented. That doesn't come up that much. What I do deal with more commonly are failing commercial real estate transactions, where the parties are more sophisticated and the brokers are almost kind of off in the side while the parties negotiate directly. And so what that does is I guess what it could do is it could create a shift where buyers and sellers have to rely more on legal advice and legal assistance as opposed to from traditional broker channels. And I don't know that the legal industry is really equipped to essentially do the job of realtors in that regard. You can't really go to a typical law office and expect them to push out a standard form contract for you on very short notice, which is what you licensees are great at doing. You move at the speed of business, and I know that when I was a licensee, sometimes you're drafting an offer on the hood of your car because that's when the parties want it done. And lawyers can be pretty quick too, but it's a change. And so I think that would probably more happen is what I said earlier, which is that people aren't going to stop using realtors by any means, but there's going to be growing pains adjusting to this new regime of cooling off periods if it gets implemented. Very important to emphasize that we don't know what they're going to do. Maybe they have great answers for all of these issues, but these are all legitimate questions and concerns.
Thanks, Michael. So now we're going to open up the questions again to just any topic that we've covered here today for Michael, and we'll try to get to as many of them as possible. I know there's already about 50 in the queue. So we'll try and get to as many as we can. Just as an FYI, we will be sending out the link to the white paper in our post-event email. And again, if you want to get it sooner, it's membernews.rebgv.org. And it's the top story there today. So if you go there today, you'll see it. And again, we'll also be sending it out in the post-event email that you'll be receiving after this event closes within the next couple of days. And that will come along with the event recording as well. We are recording this entire event, including the Q&A periods. Okay, so we're going to be going back to some questions about tenant-occupied properties. So I have a question here from Sean. In most cases, the completion date is before the possession date. How can you create a deal after this date has been completed?
Yeah, that's actually a really good question because, yeah, usually completion is afterwards. So the issue is, how do you say that I don't have to complete when you're not requiring vacant possession until the day after completion? And where this is cropping up is in two scenarios. One, the tenant basically tells someone that they're not going to be moving, and that gets back to the buyer. Sometimes the seller admits that they've been told that the buyer is not going to move out, and it's a really dangerous game for a seller to admit that the tenant is not going to move out. Because then the buyer might turn around and say, well, this is an anticipatory repudiation of the contract. So basically I have a basis to anticipate that you're not going to be able to fulfill the requirements of the contract. And it's and so that's a way it arises. But yeah, most typical way is maybe the tenant intentionally wants everyone to know so that they're part of the negotiation at that point. So the way it happens is it just gets back to the buyer one way or another.
Thanks. And I have a question here from Nicole. She's looking for some clarification. So when we're talking about tenants, we are talking about tenants in a lease. Is that why they carry so much power? If so, then would they have to leave at the end of the lease agreement? If not, she's just looking for a little bit more explanation there.
Yeah, so basically seems to be discussing fixed term leases, but to be clear, residential tenancy law is so powerful. If someone moves into your property and pays you rent, you've got a residential tenancy agreement, whether or not there's a signed agreement, whether or not there's a fixed term lease. And the whole point is that it doesn't matter that you've served a notice requiring the tenant to leave by a certain date or whether they've agreed. The whole point is tenants are increasingly just not leaving despite having gotten a notice. Or despite having agreed to leave. And so that's why your contracts need to contemplate that issue, because it's just cropping up more and more.
Thanks. Question here from Sandor. In the RTA, can a tenant be sued if they interfere with the sale of a property?
The answer is yes, absolutely. They can be sued for not leaving on time as required. If they are required to leave on time, then they can be sued. But 95% of the time, what good is that for you? Because buyer refuses to complete your deal, craters, you needed that money for something else. You're already stressed out. Do you want to go and chase a tenant who may or may not have money even to pay a judgment? Could be chasing a dry judgment at that point. So yeah, if a tenant overholds and stays past the effective date of their tenancy, they can be liable for damages. But as a practical matter, it's not really helpful to a seller to have that ability often.
Thanks. Question here from Karina again on tenant occupied properties. Can a realtor insert a clause when representing a buyer that the deal will be collapsed if the property is not vacant on possession date? Is that something that could possibly be done?
Yes, absolutely. That can be put in if a buyer wants to do that. If a buyer is going to do that, though, the realtor has to put their mind to the question and observation the other person had about how can you, if the deal completed the day before, how do you collapse a transaction that's already completed if the possession date is afterwards? And so if you're going to do that for your buyer client, then you have to make sure that that aligns with the completion date so that you're in a position where the deal can actually be collapsed. But again, where is this commonly coming up? It's because of tenants saying they're not leaving or sellers telling buyers that the tenant's not going to leave, and then the buyer basically putting on notice of the problem.
So if you were to put a clause like that in, or would be looking to do that, would you suggest contacting a lawyer then to help prepare that?
Well, the issue is until BCFSA provides standard help in wording and advice, yeah, I'm reluctant to say realtors should be drafting this language because it's not your job to draft customized language in real estate contracts. That's the other source of my litigation files is when realtors are doing that, right? And so what really needs to be done is direction from BCFSA on this point, because yeah, right now it requires custom language, and really only lawyers should be drafting custom language in contracts, as that's their whole job. And realtors obviously draft contracts, but within a certain boundaries where they're supposed to primarily rely on standard form contracts and standard clauses recommended by the regulator.
Thanks, Michael. Question here from Angie, again on tenant occupied properties. Is there any other ways to get a vacant possession besides buyer's personal occupancy?
The short answer is no, because the presumption in BC is that a tenant is entitled to stay indefinitely at the property unless they're either getting evicted for cause, like so if they didn't pay their rent or something like that, or unless the landlord intends to use the property for very two limited purposes, either redevelopment or demolition purposes. And there's a whole bunch of regulatory requirements with that. You don't just whip out a notice and say you're doing that. So it's not available in most situations. And then the other situation is when the buyer intends to move in or their immediate family member, but there's no other way, no legal way where you can serve a notice and require them to leave for no reason, basically.
Right. Question here from Jack. Have you seen any court cases of a buyer suing the vendor to compensate when the tenant doesn't leave?
The answer is I've seen very few, because this has not been an issue in the past like it's starting to be now. There are very few cases. I said in my presentation earlier that there's even divided case authority on this issue, where sometimes the court has said, yeah, the buyer can back out. And in other cases, the court has suggested that the buyer can't back out and still has to complete. I have a number of ongoing files of this kind, and I suspect other lawyers do as well. So I think we're going to start to see these kinds of cases because, like I said, I almost wouldn't be presenting on this issue 3 years ago, like before COVID. It's just become particularly bad since COVID hit, in my experience.
Thanks. Question here from Alex. It would appear that the tenant is now becoming part of the negotiation process to sell a subject property in which they're renting. What about having a lawyer prepare an agreement for the tenant to sign under oath, committing the tenant to vacate the subject property after the terms acceptable to the tenant are met? Is this a reasonable approach to guarantee the seller and buyer of a vacancy on possession date?
Yeah, and I mean, this idea of a tenant becoming part of the negotiation process, that's too bad. I mean, I understand where that's coming from. The tenant should not be part of a negotiation process, but that's just how the law is working nowadays, and that's the product of the market. And that's really too bad because this is a matter between the buyer and the seller. And but that said, in the idea of getting a tenant to sign a lawyer drafted, customized mutual agreement, first of all, the tenant doesn't have to sign that thing. And secondly, the tenant's probably not going to sign it unless they're paid compensation in excess of the 1 month rent that the Residential Tenancy Act requires them to pay. And so I would say that, yeah, if you can quote unquote buy out a tenant, that can be an effective way to resolve the matter. You're still requiring them to leave on the day when they're required to leave, and maybe you can put in language in the mutual agreement dealing with the consequences of their failure to leave. But the point is that the tenant doesn't have to engage in that process with you. They don't have to sign anything, and that's why you should be able to rely on a notice, because the law says you can end tenancies for this reason. But increasingly, as a practical matter, it's becoming difficult for owners to rely on these notices. So what do you do when the tenant doesn't leave, right?
Fits. Question here from Sharir. In a land, this is going to the multiple representation. In a land assembly, is it legal to have all owners assemble in a conference room from time to time for question answer period? Sorry, this lost the place there. To possibly bring all these hidden points?
Well, I think that sounds like a prudent idea, like a good idea, because like I said, if you're going to act in a joint listing, you have to change your approach and have full disclosure between your clients about what's going on with your marketing activities. So I mentioned earlier having an email list where you email everyone updates. That's one thing, but yeah, you might have meetings to discuss what's been going on with all of your clients. If you think that's a good idea, you don't have to do that, but you might consider it a good idea depending on the needs of your clients. The point being is that everyone has to get advised equally. There's no favoring one client versus another. I actually saw, just before you go to the next question, someone had a observation in the Q&A that, well, but different properties are unique, so maybe one will sell for less or more than the other because of features. And the answer is, I get that, and I'm not saying that that won't happen. The point is that there has to be full transparency between everyone about what's going on, so that a client doesn't feel you're favoring one client's interest over another.
Yeah, that makes total sense. Continuing with our assembly talk here, Raska is asking, in a land assembly, does the agent have to reveal the price or terms offered to each seller to the whole group?
Yeah, and so this is a really tricky situation, because going back to my slides, you have, if you just had typical MLS listing agreements signed with your clients, you've promised unconditional duties of loyalty and transparency to each of them. And this can be incompatible with a joint listing. And so I'm not going to say, yes, you do have to disclose, or no, because first of all, I can't generalize in that way to your particular situation, because it does depend. But the point of my presentation today is that you can get on top of that issue with a properly drafted joint listing agreement between the owners, and you can deal with that issue about what will happen if an offer is received. Because the problem that I'm seeing is that realtors are not really effectively acting for the group as a whole. They're letting, I've noticed that holdouts tend to get the best price. And so what realtors are doing is they're having some clients enter into contracts to sell their home as part of land assembly, and then the holdout is getting a much better price, and everyone's pointing their finger at the realtor for allowing this to happen. And if the realtor had a better relationship with their clients, managing those expectations, having a joint listing, that situation either could have been avoided or mitigated. And certainly to just have an MLS contract and treating everyone individually is, I think that's inappropriate.
Thanks. Question here from Edward. If a seller and a tenant already sign a mutual agreement to end tenancy, can the tenant still sue the owner or the new owner if the new owner decides to rent out the property?
The answer is probably not. And the reason why is because if the landlord and tenant signed a mutual agreement, the tenant is not leaving because of a notice served on them. The tenant is leaving because they agreed, they volunteered to leave. This is still sometimes the subject of some litigation. Like, I've acted for landlords who got their tenant to sign a mutual agreement, and the tenant tries to say that it's not binding on them because they were essentially defrauded into signing it, because the true intention of the landlord was just to let a buyer move in. I'm not saying that those lawsuits are successful. I'm just saying that that's what I've seen. But the idea is, when a mutual agreement is signed, the tenant is voluntarily agreeing to leave. They're not leaving because of the notice. And in such circumstances, the penalties and everything for not actually moving in presumably wouldn't apply, because those penalties apply when a tenant leaves because they're leaving under a notice to end tenancy for landlord's use.
Makes sense. Another question here. Can a buyer, this would be in the potential cooling off period, could the buyer waive the cooling off period in an offer clause?
Well, and that's the thing, is it is maybe, and if it were that easy, then what's the point of the cooling off period, right? Everyone's just going to waive. That's why I suspect BCFSA is going to take it a step further. Although how they do that exactly, I just don't know that they have the regulatory teeth to do it, because their mandate is the licensing and regulation of realtors. They don't regulate the real estate market generally under RESA. And so it remains to be seen how they'll do it. But if it were as easy as a buyer waiving the cooling off period, then what was the point of this whole exercise? Everyone's just going to waive it in a multiple offer situation.
Thanks. Question here from Ruchika. If a hearing date is set following a notice of eviction, how long does it take for the tenant to leave, and how will this need be addressed in the sale? Also, if the tenant creates trouble during showings, what are the rights of the landlord?
Yeah, and so the first part of it, I mentioned in my presentation, it can take 2 up to even 5 months lately to get a hearing. Then the arbitrator has 30 days to issue a decision, and then an order of possession will be issued. And as long as it's not appealed from, then the tenant will have to leave at that point. So it can be a long process. It can totally defeat the intentions of the buyer and the seller if it has to go all the way to that. And the second question, that was, Mark, do you have it there? I apologize. I kind of missed it. It was kind of not related.
Yeah, hold on. Let me just bring this.
Sorry
back
about that.
up. No, that's quite all right. Sorry, just got to go through the list here. I apologize.
They may have to put their question up again.
Yeah, I apologize. You might have to put your question back up again. I'm just not able to see it here.
Oh, I see it. I see it. They put it there. So the question was, if the tenant creates trouble during showings, what are the rights of the landlord? I guess it depends on what creates trouble mean, because there is a provision of the RTA that says that if a tenant knowingly gives false information to a prospective buyer, they can get evicted for that reason. But so there are remedies available, but it's not a clean and easy process where you whip out an eviction notice and you can expect them to leave right away. It's going to be a drawn out process. If you evict a tenant for giving false information, they're entitled to 1 clear month of notice. And if they dispute it, you're going to go to an arbitration 2 to 4 months from now.
Thanks. A question here from Pei. Can you have a completion date and possession date after the date the tenants vacate? She's wondering if this is a way to possibly know if the property is going to be vacant or not.
Short answer, I expect you could. I mean, the devil is in the details as to how you draft those contractual rights. But if you had a completion date that was dependent on the tenant leaving, I mean, that can be done, but I don't think realtors should be drafting that type of language. That's kind of like a complex contractual drafting task. Realtors should not be doing that.
Thanks. Question here from Gina. Illegal suites in existing homes. What can an owner do if their illegal suite has been ordered decommissioned by the city or municipality it's located in, and the tenant refuses to leave?
Well, the issue there is, if the municipality has ordered the suite to be closed, then depending on how that order has been made, the landlord actually has a basis under the Residential Tenancy Act to evict the tenant, because one of the bases you can evict a tenant is if a government authority has ordered the rental unit to be closed. However, ordering it be closed versus ordering that work be done, which is more common, that's two very different things. And if the municipality has stopped short of ordering that the unit be closed, the landlord has to do whatever the municipality is doing and can't interfere with the tenancy. And I think there's some reluctance on municipalities to order units closed, because then they're essentially participating in an eviction, and municipalities don't really want to do that because everyone knows how there's an affordable housing issue going on right now.
Thanks. So we are up to our scheduled end. Michael, do you mind staying on for a few minutes longer to help us answer some of the questions?
Let's do it.
Perfect.
Let's do it. Yes.
Great. So then with that in mind, we have a question from Adelina. Is getting an estoppel certificate a good idea as a clause to accept in a commercial transaction with residential tenants?
Residential tenants have no obligations to sign estoppel certificates. Sometimes I see this asked for in commercial deals, and if I'm acting for the seller, I'm always striking that, because you can't make a tenant sign an estoppel certificate. An estoppel certificate, if you don't know what that is, it's a document signed by the tenant where the tenant is assuring the new buyer about certain aspects of their lease, that yes, I confirm that the rent is X. Yes, I confirm that there are no defaults that the landlord is guilty of, to my knowledge, certain information like that. And the reason why you can get a commercial tenant to sign an estoppel certificate is because many commercial leases require tenants to provide these estoppel certificates from time to time. This is not found in residential tenancies. There's no prohibition against estoppel certificates, but it's just not done. No tenancy agreement that I've seen deals with that issue. And so as a buyer, you can ask for an estoppel certificate. Tenant doesn't have to give you one, and the seller is probably going to strike it because they don't want to have time wasted on that issue, trying to get a document out of someone who's not required to give it in the first place.
Thanks. Question here from Quote. Can a clause put in a contract of purchase and sale asking that the buyer can't enter into another contract of purchase and sale during the cooling off period? Is that something that's possible? Could you put something like that in?
So the only problem I have with answering that is I don't know how the cooling off regime is going to work. Maybe they'll have a prohibition that you can't do that. And so we can only speculate about that. I don't know how helpful it would be for me to speculate on that. We might as well just wait to see what they actually do. But I will say this, is that if it's really easy to work around it, that's too bad, because that defeats the whole point of the thing. And then we're just wasting time. And it turns into a situation where realtors are having to just give more disclosure forms and more regulatory stuff just for no real good reason, if that ends up happening.
Thanks. I have a question here from Zeu. Should tenants continue paying rent while the arbitration is in progress, even if it's like 3 to 5 months?
Well, the idea is that, that's kind of it's a difficult question, because basically, if the tenancy hasn't ended yet, they still have to pay rent. Like, it's still a tenancy, right? And so if I served a notice on a tenant for landlord's use and the tenant stopped paying rent, I could actually evict the tenant for unpaid rent. Maybe I get a shorter hearing date. Where it's a tricky issue, and this is not necessarily inappropriate, you shouldn't be relying on this necessarily, because there's a lot of factual parts to this. But basically, if the effective date of the tenancy has passed, so let's say the tenant was required to move out at the end of March and they haven't done so. Well, if the tenant pays rent after the effective date, the landlord has to be very careful about that, because they may be seen as having agreed that the tenancy can still continue and that the notice served beforehand is not of any further force or effect. And the way that you accept money after the effective date as a landlord is, you might say, I've received the money, but I don't agree to reinstate your tenancy, and this is for use and occupancy only for a temporary period of time until the arbitration is determined. The RTB provides policy guidelines on that, but my point to say is a landlord needs to be very careful about accepting rent from a residential tenant after having served an eviction notice, and if the tenant is staying in possession after the effective date of the notice, because they don't want to be seen as reinstating the tenancy. I saw there was another question I wanted to answer. Actually, someone asked about a certain bailiff or some enforcement company. I don't know anything about that one. I'm not commenting on that, but there's no one that can outsmart the residential tenancy law. There are people who are unlicensed, non-lawyer people who are maybe tenancy quote unquote consultants or whatever, who may say they have this magic power, but no one does. And the only way you can evict a tenant is you get an order of possession from the RTB, and anything else is an illegal eviction, and there are very serious consequences for that.
Thanks, Michael. Looks like we have one last question in the queue here from Angie. Can we write a subject to the seller and the tenant that signed and the tenant signs the mutual end of tenancy agreement before the removal if the buyer is willing to provide money to compensate the tenant? So basically, can we put a clause for mutual end of tenancy in with a monetary compensation?
You can, but I mean, if the tenant doesn't want to do it, because you can't foist a mutual agreement on a tenant, right? They have to, that's the whole point of it being mutual, right? So you can have all sorts of arrangements where maybe the buyer is agreeing to pay something, and if it works out, that's great. But I'm just trying to emphasize that you can't force a tenant to agree to anything. And it's too bad. I mean, this goes back to tenants shouldn't be part of this negotiation. They shouldn't be able to use the fact that the RTB is backlogged as leverage against landlords. And, but increasingly, I'm seeing agreements having to be worked out. And that may change. Like if more arbitrators are hired and the hearing date issue is fixed, then that will balance the status quo again. But yeah, sometimes I'm hearing about some pretty unfortunate things. Unfortunate because it seems to be an abuse of how the law was intended to work.
Thanks, Michael. Maybe I'll give just another few seconds here. Does anyone else have any other questions for Michael before we wrap up today? It's like we have a few in here. Just this one. Okay, so question from BB. In some offers from buyers, they've seen a deposit to be held by the buyer's lawyer versus the brokerage. Are lawyers bound to the same stakeholder status as brokerages?
Yeah, and the answer is they will agree to be bound. I mean, it's kind of sloppy to have, and I know this, I shouldn't criticize, obviously many people do this, but the deposit clause that person is referring to was really designed and intended for to be used in the situation where a brokerage holds the deposit as stakeholder, because it references a section of RESA that talks about how brokerages hold deposits as stakeholders. Now, if instead of a brokerage that deposit clause mentions a law firm, I suspect that the law firm is going to be held to the same basis as a stakeholder. They're not going to, it would be unlikely to say that somehow the lawyer is not holding it for both parties, because the whole point is the contract said that this deposit was going to be held as a stakeholder. And there's nothing in RESA that I'm aware of that says that persons other than brokerages can't also be stakeholders, even though the whole law is designed around the idea that brokerages are stakeholders. Nothing says that they are not necessarily stakeholders either. Thanks, Tina.
Question here from Jimmy. Once the RTB allows the eviction and the tenant will still refuses to leave, how long does it take to have a marshal do the job to evict, and how much does it cost, and who pays for the marshal?
Yeah, good question. So just to be clear on the terminology, I think some jurisdictions in the United States call them marshals, but here in BC, they're called court-appointed bailiffs. And they can get in pretty quick, although we're still talking 1 to 3 weeks. And I've seen it, and it really, how much it costs depends on how much stuff the tenant has in many respects, because the bailiffs have to supervise the movers who remove the stuff from the property. So I've seen it as cheap as $3,000. I've seen it as expensive as $15,000, depending on what's going on with the property and what possessions are there. And like, if the tenant has something tricky to remove, like a boat or something like that, that's a lot, obviously a bigger issue and more difficult to remove than if it's just a 1-bedroom apartment, right? And yeah, who pays for the bailiff? Well, usually the landlord does, but that's another thing that goes back to my lecture earlier, sorry, not lecture, my presentation earlier about sorting these issues out. I mean, why should the seller get stuck with that bill when the buyer caused this mess in the first place by asking the notice to be issued? That's an arguable position, but this has to be sorted out between the parties.
Thanks. One last question here from BB. Commissions are between brokerages as per the multiple listing contract. A lawyer is not necessarily entitled to a sales commission if the buyer chooses to work with a lawyer instead of a realtor. Is that correct? Or would that be an agreement between a buyer and their lawyer?
So the reason realtors get paid is because under the MLS rules of cooperation, everyone who's part of a real estate board, like the Real Estate Board of Greater Vancouver, has agreed to this commission sharing arrangement. So if you get someone like a lawyer who is authorized to conduct real estate trading activities, they're actually exempt from RESA, but they're not part of the real estate board and haven't signed on to the rules of cooperation, that lawyer better be sorting out how they're going to get paid with their client. They're going to expect to get paid by their client. And so the idea that the listing realtor owes the lawyer a commission, even though the lawyer is not part of the real estate board, that's very tricky. I don't know that a lawyer could put themselves in that position, but there may be more. If this is about a particular fact situation, well, I'm not giving advice on your particular situation, but it does seem, how can you make a listing realtor pay a commission when the other person hasn't signed on to the MLS rules of cooperation, is what I wonder about that. So I think I'm doubtful about it.
All right, thanks, Michael. Looks like we're going to wrap up here today. I really appreciate you coming out and speaking with us. That was really informative. I know that I learned a lot about this, and I'm sure our members in attendance did as well. To our members here, we'd also love to hear your feedback from today's session. When you log off, you'll get a pop-up link to our event survey. Please fill it out. It only takes a couple of minutes, and share your thoughts with us. These surveys really help us develop further one-off events like this, and gives us feedback on how we can improve in the future. I'd also like to mention some upcoming events that you may be interested in. On March 16th, we have a Realtor Code of Ethics event, and that's with our ethics guy, Kim Spencer. We also, on March 23rd, have authorized access with Steve Chappelle. Both of those are open for registration right now. So if you go to your courses and events calendar at rebgv.ca, you'll be able to register. Well, thanks for taking the time with us this morning, everyone, and appreciate you coming out. And again, Michael, thank you on behalf of the Real Estate Board of Greater Vancouver.
Great,
Have a
awesome.
great day.
Thank you. Bye, everyone. Have a good day.